It's good to see you all, and really good to see you all in person. So I thank you for coming here and lending your presence. We're glad to be kind of recongregated. This has been a very, very unusual few years, but one constant has been the legal education here at Penn Law, as well as the leadership and convening and incisive discussions facilitated and led by the Institute for Law and Economics and our faculty leaders and leaders from practice and across the university. So that's continued. It's continued in different settings, and it's great to be back here in a primarily in-person setting. I have my notes that I often use to introduce these events, and what I have said for years is the ILE is physically based in the law school, but actually a joint research center of the law school, Wharton School, and Penn's Department of Economics, and draws from across the university. So I would just edit that to physically and I guess virtually based in the law school, because the ILE and its leadership and all of you did so well convening during the pandemic. But we're really glad to be back here, sort of in the best traditions of ILE, bringing together leaders from practice and different disciplines and students and recent alums and not so recent alums, and one of our most distinguished alumna, namely Justice Valihura, who is joining us from the Delaware Supreme Court. And I really, you'll be more properly introduced by a colleague, but it's wonderful to have you here, and thank you for speaking with us. I see your topic is creating common law in the corporate context, which strikes me as a teacher, and I'm doing more teaching during the pandemic of so-called public law topics like constitutional law, like healthcare law, and it strikes me that a lot of those areas are less and less common law, more anti-discrimination rules, privacy rules, much more likely to be statutes and regulations. It's a point I make in those classes, and I realize that sort of the common law tradition very much alive and well in corporate law and in the Delaware courts, and we have one of the leading framers and practitioners of that, and so thank you for sharing your words. I want to thank the faculty and staff leadership of ILE for their role through the pandemic and through today, and I will hand it off to one distinguished colleague, Professor Jill Fish, to better introduce the program and our guests. Thank you.
Thanks, Ted, and I'm kind of patting myself on the back because I think I finally adjust to Ted's standard introduction and managed to eliminate some of the duplication that would otherwise be in my remarks. So I'm going to be very brief because I know you all want to hear from Justice Valihura. But on behalf of my faculty co-director colleagues, Elizabeth Coleman and Lisa Fairfax, the University of Pennsylvania Carey Law School, the Institute for Law and Economics, Executive Director Larry Hammermesh. It's my great pleasure to welcome the Honorable Justice Karen Valihura to deliver the Distinguished Jurist Lecture. As I was preparing my opening remarks, I realized that our last Distinguished Jurist Lecture was in the fall of 2019 by then SEC Chair Jay Clayton. And it's been an interesting 2.5 years since then. As you know, we've resisted the temptation to shift Justice Valihura's lecture to an online format. We sort of hoped and prayed for the day that we could all be here in person, and I'm so glad that we're finally able to make this happen. I'm also really grateful to all of you for making the effort to extricate yourself from your couches and to brave the foul weather and to be here in person with us today. Before I forget, some of you are here, at least in part, because of the CLE credit here. But for those of you who are seeking CLE credit, your first CLE word is internal affairs. I don't mean anything by that. So as you know, the Distinguished Jurist Lecture really is ILE's crown jewel. It's our opportunity to spotlight judges, regulators, policymakers who've had particularly distinguished and noteworthy careers and who've had an impact on the legal profession. We bring leaders in business and business law to the law school, to the university, and to the broader business, legal, and judicial community. And of course, we've got some great judges who are here celebrating with us as well. So in that light, I can think of nobody who's better suited to deliver this year's lecture than Justice Karen Valihura. Justice Valihura was sworn in as Justice of the Supreme Court of Delaware on, if I have the date right, July 25th, 2014. She was the second woman appointed to the Supreme Court. I'm looking at Lisa and thinking about women appointed to Supreme Courts, right? A particularly auspicious day for you to be here and to honor women being appointed to Supreme Courts, right? Prior to her appointment, Justice Valihura worked at Skadden Arps, where she became a partner in 1997, and that in itself is a really distinctive feat. 1997, for me, doesn't seem like that long ago, but you know, women achieving that kind of position was really distinctive back then. She practiced corporate litigation, including complex commercial and corporate governance issues, securities matters, M&A, and other transactional litigation. As a practicing lawyer, she was consistently recognized and honored. She was, for example, selected for inclusion in Chambers USA, America's Leading Lawyers for Business, and the Best Lawyers in America. Justice Valihura has also been distinguished by her extensive public service. Here at Penn, we really appreciate and value public service, and her public service extended to well before she joined the bench. She served on the advisory board of the Weinberg Center for Corporate Governance, chair of the Delaware Supreme Court's Board on Professional Responsibility, so the students who are studying for the professional responsibility exam, right? She's your go-to person. And she was a chair of the Delaware Supreme Court's Permanent Ethics Advisory Committee on the Delaware Rules for Professional Conduct. She served on the Corporation Law Council of the Corporation Law section of the Delaware State Bar Association. She was on the board of the Delaware Special Olympics for 18 years, including service as the board's president. She was a member of the Delaware Bar Foundation, including service on that board's president. And she was the first woman to serve as president of the Bar Foundation. On the Supreme Court bench, Justice Valihura has been a leader on business law issues as well as other issues. Students in the room are well familiar with her work, both on behalf of the full court and in dissent, because you've read many of her opinions in class. Cases like, Shabakuki, Dell, Manti, right? Just to name a few, and you can grill her on those during the cocktail reception. We're, of course, very happy, as Ted said, to claim Justice Valihura as a Penn Law alum, where she was a member of the Law Review. She's been a terrific and loyal supporter of the law school. We're very, very happy to have her back. So with that, Justice Valihura.
Thank you, Dean Ruber and Professor Fish. It's a very distinct honor to be here at the ILE. The title of my lecture is Creating Common Law in the Corporate Context, Delaware Style. Common law has been defined as the body of law derived from judicial decisions rather than from statutes or constitutions. Today, my focus is on crafting judicial opinions in the area of Delaware corporate common law and on the factors that shape and have shaped my decision-making, with my disclaimer that the views are solely my own and not of the court's. Let me begin by asking, what are some of the principles that are important in crafting judicial decisions? I will focus on my five Ps. These principles in part act as guide rails and guideposts in imposing boundaries in crafting these opinions. First, there's purpose. What is the purpose of a particular law? How did it come about? Second, there is practicality. Is the common law functionally serving its purpose? Third, there is precedent, and a strong corollary to precedent is predictability. Has the common law developed in a logically iterative fashion to adequately allow people to understand where the legal boundaries are? And fourth, there is public policy. Are there recognized, long-standing, and perhaps even overriding societal values that should be considered in crafting the holding of a case? And finally, there are procedural principles and judicial perimeters, I'll call them, including the doctrines of judicial restraint, waiver, standards of review, and jurisdictional boundaries that can impose limitations on judicial action. I will attempt to illustrate these principles referring to cases decided primarily by the Delaware Supreme Court within the last year. I would be remiss if I did not give great credit to our excellent Court of Chancery, its outstanding jurists, and the critical role that court has played in shaping our Delaware corporate law. Several of the cases I will highlight how our Court of Chancery has been the incubator for the emergence of several key recent developments. So let's start with my first principle, purpose. Oliver Wendell Holmes, in his book The Common Law, published in 1881, said, "The life of the law has not been logic. It has been experience." He wrote, "The law embodies the story of a nation's development through many centuries, and it cannot be dealt with as if it contained only the axioms and corollaries of a book of mathematics." Well, the development of the common law has been based upon our experiences over time. And I do think logic has a role in decision making, but I agree with Justice Holmes that the main driver has been human experience. The particular purpose of a common law doctrine could be seen as a way of addressing various kinds of human behavior and experience. Let's start with the basic common law concept that no person shall profit by his or her own wrong. This is the animating principle behind the so-called Slayer's rules, common law rules barring life insurance recovery or inheritance flowing from a decedent's murderer. As the Court of Chancery explained in one case, this type of audacity is illustrated by a murder defendant who has killed his mother and father and then throws himself on the mercy of the court as an orphan. Or consider the societal consensus that lying is wrong. That is something we're taught as young children. But let's see how that simple concept, lying is wrong, has appeared in the area of fashioning common law limits on contractual remedies in the corporate arena. And since he's here, I will use an illustration by former Chief Justice Strine's decision in Avery Partners versus F&W Acquisition to illustrate how our common law has dealt with the following question. To what extent can a contracting party limit its liability for its own intentional misrepresentations? This decision illustrates well the tension between two fundamental principles developed in our common law. The first principle is our simple concept that deliberate lying is wrong, fraud is wrong, and as a corollary, no person should profit by his or her own lying and fraudulent conduct. A countervailing principle is what our Delaware courts have described as a strong American tradition of freedom of contract. Our courts have stressed the importance of having commercial laws that are efficient and clear in order to facilitate commerce. In Avery, those two principles clashed and resulted in a decision drawing a boundary line between the two and establishing a clarifying precedent for future cases. There, a private equity firm bought all shares of a publishing company and alleged that the seller, another private equity firm, had fraudulently induced it into entering into a stock purchase agreement. By its plain terms, the agreement stated that the buyer had promised that it was not relying on representations and warranties not contained in the agreement, and that no such other representations had been made. The agreement went further. It limited the liability of the seller for any misrepresentation of fact contained in the agreement to a capped damage award not to exceed $20 million. So once the buyer assumed ownership of the company, the buyer began to uncover a host of serious problems. Buyer concluded that it had been defrauded by the seller. Buyer alleged that the seller and company management working in concert had schemed together to manipulate the company's financial statements in order to fraudulently induce the buyer to purchase the company at an excessive price. Well, notwithstanding the undisputed fact that the agreement limited the buyer to a capped money damage award, the buyer sought a different remedy, namely to rescind the agreement altogether. So even though the buyer had agreed to a limited capped money damage award, the buyer argued that Delaware's public policy ought to override the buyer's own agreement. The buyer argued that Delaware's public policy should not allow a contracting party to immunize itself from a rescission claim based on false representations of fact contained in the written contract, which representations both sides agreed were important for their decision to contract in the first place. So the issue as framed by the Court of Chancery was whether the contract that limited the buyer's remedy was broad enough to encompass even intentional misrepresentations of fraud. If it was, then the second issue was whether the remedy on cap damage award would be overridden on public policy grounds. So how did the Court of Chancery resolve this dispute? First, it confirmed that the plain terms of the contract, absent an overriding public policy, would indeed limit the buyer's money damages claim to a capped award. So then the court was left with the remaining difficult question of whether public policy would override that contractual limitation. The court's opinion in Avery presents an interesting discussion and reconciliation of these competing long-standing principles. The court acknowledged the strong tradition in American law that contracts may not insulate a party from damages resulting from the party's fraudulent conduct. On the other hand, the court noted the equally strong American tradition of freedom of contract. Delaware law respects the ability of sophisticated parties, like buyer and seller, to make their own judgments about the risks they should bear. But this concern for commercial efficiency, said the court, does not mean there should be no limits, public policy limitations, on the contractual exculpation of misrepresented facts. In fashioning its resolution of the issue, the court differentiated between intentional lies and unintentional misrepresentations of fact, noting even that there was a behavioral and a moral difference between the two. In the end, the court held that to the extent the agreement limited the seller's exposure for its own conscious participation in the communication of lies to the buyer, that limitation was invalid under the policy of our state. As the court said, the public policy against fraud is a strong and venerable one that is largely founded on the societal consensus that lying is wrong. That brings us right back to the simple proposition and behavioral norm that we started with. By contrast, the buyer would be stuck with its agreement on any lesser showing. Well, let's see how these principles, very wisely articulated by then Chancellor Strine and Avery, were applied in two fairly recent cases decided by the Delaware Supreme Court. First, in Express Scripts versus Bracket Holdings, decided in February of 2021, the Delaware Supreme Court wrestled with this same tension between the public policies concerning freedom of contract and fraud in a case involving Bracket Holdings' purchase of Express Scripts. Bracket and Express Scripts subsidiary, United Biosource LLC, had signed a $187 million securities purchase agreement whereby UBC agreed to sell 3 of UBC's businesses to Bracket. Except for claims involving deliberate fraud and certain fundamental misrepresentations, Bracket agreed to limit its remedy for breach of the agreement's reps and warranties to an insurance policy purchased for that purpose. After closing, Bracket claimed that Express Scripts and UBC engaged in fraud by inflating the revenue of one of the divisions of the acquired companies. Bracket sued Express Scripts and UBC for fraud in the Delaware Superior Court. A jury awarded Bracket over $82 million. The parties appealed, and we found one issue dispositive. The agreement provided unambiguously that except in the case of deliberate fraud, Bracket could only recover up to the policy's limits for breaches of representations and warranties. Over Express Scripts' objection, however, the Superior Court had instructed the jury that it could fine for Bracket not only for deliberate fraud, but for recklessness. In reversing, we emphasize that a deliberate state of mind is a different kettle of fish than a reckless one. This harkens back to the line drawn in the Avery case. The Superior Court's erroneous jury instruction was not harmless. It had violated a key provision of the agreement and how the parties had allocated risk in the transaction. In a second recent decision, RSUI versus Murdoch, decided by our court a month later, we considered the same tension between a contractual provision which provided insurance coverage for fraudulent conduct and competing public policy concerns. There, our court determined that the allegations of fraud did fit within the directors and officers' terms covering this, defining the scope of coverage. So the question we considered was whether that contractual coverage for fraud should be overridden on public policy grounds. Thus, the insurance company's public policy argument, if accepted, would defeat the parties' contractual expectations. The question in our SUI then was, does our state have a public policy against the insurability of losses occasioned by fraud so strong as to vitiate the parties' freedom of contract? In affirming the Superior Court, we held in that case the public policy would not override the contract. You might say, well, this seems inconsistent with the two cases that I just discussed. But what we did was we looked to whether the General Assembly had delineated the bounds of contractual freedom in this area. We found the answer by comparing two subsections of Section 145 of the Delaware General Corporation Law. Section 145 limits a corporation's authority to indemnify directors and officers for expenses incurred if the person in his or her underlying conduct acted in good faith and in a manner the person reasonably believed to be in or not opposed to the best interests of the corporation. But by comparison, Section 145G broadly authorized the purchase of directors and officers insurance against, quote, any liability asserted against the directors and officers, whether or not the corporation would have the power to indemnify such person. The limitation found in Section 45A on a corporation's authority to indemnify, when read together with 145G's broad authorization to secure insurance against any liabilities for which the corporation does not have the power to indemnify, suggested to us that the corporation had statutory authority to obtain directors and officers' liability insurance arising from bad faith conduct. Let me turn to the second principle, practicality. What happens in the corporate common law when it no longer addresses in a satisfactory manner the matters it was intended to address? Although our focus today is not on statutory law, our Delaware General Corporation Law, as many of you know, is revised continually to address new situations. With regard to appraisal, before the Delaware Appraisal Statute was enacted, at common law, no merger or consolidation could be effected except with the consent of all stockholders. How difficult is it to get 100% of the people to do anything? And so the common law scheme proved to be unworkable due to this problem of holdouts. And there it was addressed not by the courts but by the General Assembly, which created the appraisal remedy in 1899. And it became a limited legislative remedy developed as a means to compensate stockholders of Delaware corporations for their loss of the common right to prevent a merger or other consolidation. There are some recent examples where our courts have changed the law to address practical problems and new developments. Take, for example, the court's decision in United Food and Commercial Workers versus Zuckerberg, decided by the Delaware Supreme Court in September 2021, where we adopted the Court of Chancery's refined three-part demand futility test, which now applies to all derivative cases. There, stockholders filed a derivative action challenging a reclassification that was ultimately abandoned. As a result, the litigation was mooted. The pension fund filed a derivative case seeking to recover the $90 million Facebook had spent in defending and settling the class action. The fund did not make a litigation demand, and the Court of Chancery dismissed the case pursuant to Rule 23.1, applying a new three-part demand futility test that in effect blended the Aronson and Reals test. And under this new test, the court assesses on a director-by-director basis whether at least half of the board, one, receives a material benefit from the alleged misconduct, two, faces a substantial likelihood of liability on any of the claims, or three, lacks independence from someone who received a material personal benefit or who would face a substantial likelihood of liability on any of the claims. And significantly, the court held that exculpated claims do not excuse demand under the second prong of Aronson. If the answer to any of the questions is yes for more than half of the board, for at least half of the members of the demand board, then demand is excused as futile. So it's no longer necessary to determine whether the Aronson or Reynolds test governs a complaint's demand futility allegations. Although not unanimous, the weight of Delaware case law, as it had developed over time, supported holding that exculpated care violations did not excuse demand under Aronson's second prong. But a few cases went the other way, noting that Aaron's second prong asked about the substantive nature of a challenged transaction and the board's approval thereof, not whether the directors faced a substantial likelihood of liability. I thought this was a difficult case, and both sides had made good points, but our court ultimately adopted the new test formulated by the Court of Chancery, recognizing that certain legislative and case law developments over the decades since Aronson had weakened the connection between rebutting the business judgment standard and opposing directors to a risk that would sterilize their judgment with respect to a litigation demand, and that the Aronson test had proved difficult in many contexts to apply, such as where there's turnover on the board. There are numerous interesting recent examples of how the case law has been developing in response to unique circumstances, including in response to COVID-19. Of note in this regard is a recent trilogy of busted deal cases, which is becoming known as the A trilogy, Acorn, Anthem, and A.B. Stable. These decisions are factually complex and are not amenable to any kind of in-depth discussion here. The trial court's decision in Anthem, for example, was 306 pages. Acorn was 246, and A.B. Stable was 241. Now let me focus on one interesting facet of those cases, which is the development of the law regarding ordinary course covenants and merger agreements. If you recall our 3-page order affirming the decision in Acorn, which was in 2018 before COVID, we expressly said that we were not addressing whether as the Court of Chancery had found Acorn had breached the ordinary course covenant. Rather, we affirmed the decision below on 2 other grounds involving the material adverse effect provision. However, in A.B. Stable, our court did directly address the operation of the ordinary course covenant, and this was the first case addressing a busted deal arising out of the COVID-19 pandemic. The Court of Chancery had issued a post-trial opinion holding that a seller's failure to comply with interim operation covenants gave the buyer the right to terminate the buyer's agreement to purchase a business owning 15 luxury hotels. It was a deal valued at over $5.8 million. Although the Court of Chancery rejected the buyer's argument that economic and business effects related to the COVID-19 pandemic constituted a material adverse effect under the agreement, the court found that the seller had breached the sale agreement's standard ordinary course covenant and title insurance conditions. In its post-trial opinion, the court concluded that the seller had breached the covenant by making extraordinary changes to the business that had departed radically from the normal and routine operation of hotels and were wholly inconsistent with past practice. In so holding, the court considered what the phrase, only in the ordinary course of business, consistent with past practice in all material respects, meant. It read the use of the adverb only in conjunction with the phrase consistent with past practice to mean that the parties had created a standard that looks exclusively to how the business has operated in the past. It concluded that the ordinary course covenant imposed an overarching and absolute obligation, and it did not incorporate a material adverse effect exception. The seller appealed, and according to the seller, acting in the ordinary course of business included being able to make proportional changes in response to extraordinary circumstances, and that the parties had allocated a risk of the pandemic to the buyer through the material adverse effect covenant. To harmonize the 2 covenants, the seller argued, the court should have recognized that the ordinary course covenant permitted reasonable industry standard responses to systemic risks allocated to the buyer by the material adverse effect provision. Not doing so, they said, negated the risk of allocation in the sale agreement. Sitting en banc, our court issued a decision affirming the Court of Chancery. In the agreement, there was a consistent with past practice modifier, but there was no commercially reasonable efforts qualifier. So we agreed with the Court of Chancery that the requirement that the seller operate only in the ordinary course and consistent with past practice in all material respects meant that its compliance was measured by its operational history and not that of the industry in which it operates. Further, the lack of a reasonableness qualifier when commercially reasonable efforts qualifiers were used elsewhere in the agreement meant the ordinary course covenant was absolute. We further observed that the parties could have, but it did not restrict a breach of the ordinary course covenant to the events that would qualify as an MAE. Our in-bank court also took note that the seller was free to make reasonable changes needed by the pandemic if it merely sought buyer's consent. But it was undisputed that the seller never obtained that consent before making drastic changes to the business operation and did not cure when given an opportunity by the buyer. So we noted, as did the trial court, that compliance with a notice requirement is not an empty formality. This court's examination of practical aspects and functionality of case law is also illustrated by our recent decision in Brookfield Asset Management versus Rawson, which we also decided in September 2021. So you can see we've been busy. This was an interlocutory appeal from an order of the Court of Chancery holding that former stockholders of Terraform Power had direct standing to challenge Terraform's 2018 private placement. The trial court held that plaintiffs did not state a direct claim under the seminal case, Delaware Supreme Court case Tooley versus Donaldson, Lufkin, and Jurist, but did state direct claims predicated on a factual paradigm strikingly similar to that set forth in the case Gentile versus Rosette, and that Gentile was controlling here. In other words, the court thought Gentile was incorrectly decided, but it was bound by it. The appellants contended that Gentile was inconsistent with Tooley and that this court's decision had created confusion in the law and ought to be overruled. Well, overruling a precedent of our court is a big deal. That should be done and can be done only with a panel of 5 justices, not 3. And it should only be done after a full and fair presentation by the parties and a searching inquiry by the court. But we did exactly that, and we overruled Gentile. Time does not permit a discussion of the facts of these cases, so I'm going to focus on the big picture terms of what we considered in overruling one of our own precedents. In Gentile, this court found separate and independent direct and derivative harms involving economic and voting power dilution resulting from an alleged overpayment by a corporation or assets of a controlling stockholder. Regarding Gentile, the Court of Chancery in Brookfield, in its trial court opinion, observed that the current law, as a matter of doctrine, was unsatisfying, but it concluded that it was bound by that precedent. A key point about the Tooley decision was that the Delaware Supreme Court had tried to create a simple test of straightforward application to distinguish direct claims from derivative claims, which is a difficult area of law. But 2 years after deciding Tooley, this court decided Gentile. Gentile was seen by many as a departure from the clarity that had been achieved by the Tooley case. On appeal in Brookfield, the appellants contended that the plaintiffs' claims were exclusively derivative under Tooley and that the Supreme Court's decision in Gentile had deviated from and was doctrinally inconsistent with the simple analysis set forth in Tooley. They also argued that Gentile contradicted and undermined long-standing case law, complicated real-world transactions, and was superfluous given existing legal remedies, and that stare decisis was inapplicable. The bottom line is that we agreed and overruled Gentile. But even before our decision in Brookfield, the Supreme Court had earlier curtailed an expanded application of Gentile in our decision in El Paso. The challenge transaction in El Paso did not fall squarely in the Gentile paradigm, and so we didn't consider overruling Gentile in that case. However, as I said, we declined to expand Gentile further. And in his separate opinion, Chief Justice Strine more directly questioned Gentile's continued viability as sound law, writing that Gentile was a confusing decision which muddied the clarity of our law in an important context, and that it could not be reconciled with the strong weight of our precedent. This aspect of Brookfield leads me to a discussion of stare decisis in my third principle, which is precedent and predictability. The discussion of Avery, RSUI, and Express Scripts illustrates how our courts have taken basic principles governing human behavior and have crafted judicial decisions. It also shows an attempt to try to achieve consistency in our common law by adhering to and building upon prior precedents. Why is predictability important? One obvious reason is that people need to know where the boundary lines are that govern their behavior. Predictability is important in every area of the law. The Delaware courts have recognized this. We took these concerns into account in Brookfield when we overruled Gentile. As we explained in Brookfield, when examining a question of law in a prior case, the essential danger is that the parties have acted in reliance on the answer that the court previously gave. There's no hard and fast rule for when a decision is or is not immutable, because the nature of reliance interests at play are highly context-specific inquiries. We recognized also that precedent should not be overturned by narrow majorities, and very recent precedent should not be lightly overturned when the only change is the composition of the court. Mere disagreement with the reasoning and outcome of a prior case, and I would submit even strong disagreement, is not enough justification for departing from that precedent, or else stare decisis would have no meaning. So we summed it up in Brookfield as follows. We said, this court decided Gentile 15 years ago. That is old enough, we think, that we can properly say that the practical and analytical difficulties courts have encountered in applying it reflect fundamental unworkability and not growing pains, but it's not so old to carry the weight of antiquity. Moreover, that gap in time has given us the perspective to see that Gentile is more of a departure from the then recent Tully than the continuation we perceived it to be at the time. Any reliance was further muted by El Paso, from which parties could rightly anticipate that Gentile's continued viability was in doubt. And finally, in overruling it, we speak unanimously with the concomitant aid to certainty that provides. This was not the first occasion our court reversed one of our own precedents. We did so in a case called Genuine Parts versus CPEC in 2016, where we held that foreign corporations are not subject to general jurisdiction in Delaware simply because they have registered to do business and have a registered agent for service of process in Delaware. Our holding overruled in part our court's landmark decision in Sternberg versus O'Neill, decided in 1988, where our court had held that foreign corporations could be subject to personal jurisdiction in Delaware, notwithstanding the absence of the claim's connection in Delaware, on the grounds that foreign corporations have consented to jurisdiction by registering to do business. Here, the impetus for overruling Sternberg was two decisions by the U.S. Supreme Court, the Goodyear and the Daimler case. And citing these decisions, our court in CPEC said that the Delaware registration statute provides a means for service of process and does not confer general jurisdiction. Our court warned, quote, that an incentive scheme where every state can claim general jurisdiction over every business that does any business within its borders for any claim would reduce the certainty of the law and subject businesses to capricious litigation treatment as a cost of operating on a national scale or entering any state's market. This court's respect for its own precedent and principles of stare decisis contribute to the court's stability during a time when its composition changes. During the past couple years, the Delaware Supreme Court justices have issued separate opinions a bit more frequently than it historically has. What does it mean when the justices disagree? Separate opinions might signal possible shifts in the law, see El Paso, or separate opinions might have the effect of narrowing the majority holding, or it might just be that unanimity was simply not possible on the issue presented. The separate opinion of the Delaware Supreme Court's recent decision in Cox versus Communication versus T-Mobile raised an interesting question in that last regard. There, the en banc court divided over how to interpret a provision in the settlement agreement between corporate entities. In a 3-2 split, the majority declared the provision to be an unambiguous Type 2 preliminary agreement that merely obligated the parties to negotiate open terms in good faith. The Vice Chancellor had found the provision to be unambiguous, but concluded that it meant something different than what the majority said it meant. In my separate opinion, joined by Justice Montgomery Reeves, we maintained that both readings were reasonable, and as a result, the provision was ambiguous. We acknowledge that the law is well settled that a party's disagreement over the meaning of a contract doesn't render it ambiguous, necessarily. But there is case law that suggests that when members of a panel disagree, that suggests there is more than one reasonable reading. Of note, in Cox, of the 6 judicial officers who examined the provision, 3 justices saw it one way, and 2 justices and the Vice Chancellor saw it another reasonable reading. I would submit that the argument that there is only one reasonable way to read the provision is somewhat diluted under those circumstances. But I think it's fair to say that our court does strive for unanimity where possible. And I recognize also that having split opinions in matters of contract interpretation may not be desirable. However, sometimes it's unavoidable. Let me proceed to my 4th point, how public policy considerations shape the development of the common law in the corporate context. Let's use an example, our court's recent decision in Manti Holdings versus Authentics, where we wrestled with some significant public policy issues. In Manti, in 2017, a third-party entity acquired Authentics Acquisition Corp. The cash from the merger was distributed to the stockholders pursuant to a waterfall provision, and the Authentics common stockholders received little to no consideration. A group of common stockholders filed a petition for appraisal in the Court of Chancery, and Authentics moved to dismiss, arguing that the petitioners had waived their appraisal rights under a stockholders' agreement that bound the corporation and all of its shareholders. The Court of Chancery granted the motion to dismiss, holding that the petitioners had agreed to a clear provision requiring that they refrain from exercising their appraisal rights with respect to the merger, and the Delaware Supreme Court affirmed in a 4-1 decision. The majority held that as a matter of public policy, there are certain fundamental features of a corporation that are essential to that entity's identity and cannot be waived. Nonetheless, it was the majority's view that the individual right of a stockholder to seek judicial appraisal is not among those fundamental features that cannot be waived. As the lone dissenter, let me focus on a couple of the policy-laden points. There was an argument that I made regarding whether or not there was requisite clarity to effect a waiver of a statutory right. But as a matter of policy, the dissent argued that even if the waiver were sufficiently clear and unambiguous, permitting waiver of fundamental corporate governance rights in a stockholders agreement, as opposed to, for example, the corporation's charter, was potentially problematic. There are some commentators, including some excellent articles by Professor Jill Fish, who have pointed out the dangers of stealth governance, and have argued that using shareholders' agreements for corporate governance could potentially sacrifice critical corporate law values. The scope of these stockholder agreements now includes putative restrictions or waivers on inspection rights, as well as appraisal rights, and bringing the ability to bring fiduciary duty claims against directors. Another concern was this question of whether ex ante waiver of appraisal rights for common stockholders was even presently permissible at all. I think there's a general consensus, and the majority acknowledged that at least some provisions of the Delaware General Corporation Law are mandatory. even, as I said, even the majority agreed with that. But moving from that starting point, there's considerable debate as to which provisions are mandatory. No doubt resolving that debate is a difficult task. There is, for example, a notion that a Delaware corporation is a different brand of entity as compared with alternative entities and is known to have certain key fundamental features. Although I acknowledge that this was a very close call, I believe the better view was that appraisal rights were mandatory. But generally speaking, the back and forth of having separate opinions is an interesting way of framing the issues, refining the issues, and ultimately shaping the opinions. The majority's holding in Manti is narrowly circumscribed, where they held, quote, accordingly, we hold that Section 262 does not prohibit sophisticated and informed stockholders who were represented by counsel and who had bargaining power from voluntarily agreeing to waive their appraisal rights in exchange for valuable consideration. They also narrowed it further by saying, quote, there may be other stockholder rights that are so fundamental to the corporate form that they cannot be waived ex ante, such as certain rights designed to police corporate misconduct or to preserve the ability of stockholders to participate in corporate governance, allowing authentics to enforce the refrain obligation against petitioners does not mean that ex ante waiver of all other stockholder rights would be enforceable. So which provisions ultimately are deemed to fall in the category of mandatory will have to await further development of our corporate law. So let's turn to the last area, procedural principles and judicial perimeters. Let's focus for a minute. There are many. We don't have time to discuss them. The law of waiver, principles of standing, standards of review are things that can all act as guardrails in fashioning judicial opinions. But let's focus for a minute on jurisdictional boundaries. As between our state government and the federal government, we have tried hard to stay in our lane or within our state jurisdictional perimeter. We can see this sensitivity in a few cases involving the reach of certain forum selection provisions. In the Boilermakers case versus Chevron, the Court of Chancery held that Section 109 authorized a forum selection bylaw designating the Court of Chancery as the exclusive forum for four kinds of lawsuits: derivative suits, fiduciary duty suits, suits under the DGCL, and internal affairs suits. The Court of Chancery, in an opinion by then-Chancellor Strine, addressed the plaintiff's attempt to identify hypothetical situations where the challenged bylaws would operate unreasonably by precluding plaintiffs from bringing claims, such as derivative claims under the Exchange Act of 1934, that must be brought in federal court. The court observed that facially, neither of the forum selection bylaws purports in any way to foreclose a plaintiff from exercising any statutory right of action created by the federal government. The court also noted that the Chevron bylaw had been amended to expressly allow cases to be filed in any state or federal court in Delaware with jurisdiction over the subject matter and parties. Our decision in Salzburg came later. There we stressed the harmony between Delaware corporation law and federal securities law, stating, quote, this court has viewed the overlap of federal and state law in the disclosure area as historic, compatible, and complementary. In Salzburg, several Delaware corporations had charters with federal forum selection provisions requiring any actions arising under the Federal Securities Act of 1933 to be filed in federal court. The 33 Act, unlike the 34 Act, allows plaintiffs to file in state or federal court, and it bars removal from state to federal court. We held that these federal forum provisions were facially valid under Section 102B1 of the DGCL, which broadly defines what charters may contain. In Salzburg, our court emphasized that Delaware historically has and should continue to be vigilant about not stepping on the toes of our sister states or the federal government. Our approach in CPAC, where we overruled Sternberg, also suggests a similar concern about minding our boundaries. We stated further that under a sensible goose and gander approach, Delaware should be prudent and proportionate in exercising jurisdiction over foreign corporations. This was perhaps a more formal way of saying that we are mindful of staying in our judicial lane. There are other interesting decisions in this regard. I think we're nearing the end of our time, so I will not comment further. There is a Boeing case out there. I'm not going to talk about that. A lot of you probably would like, but I'm not going to. But given our time constraints, this is a good place for me to bring this lecture to conclusion. I have taken you on a whirlwind tour of some of our recent and fascinating Delaware Supreme Court decisions, and we've touched on all 5 principles: purpose, precedent, practicality, public policy, procedural principles, and judicial perimeters, guideposts which play a role, at least for me, in crafting and shaping our common law. Given the breadth of the topic and our time available, we've only lightly touched on the fascinating subject of the art of creating common law in the corporate context, Delaware style. If you will indulge me for one final paragraph, I want to thank you for inviting me to speak. I am so grateful and honored to be here in my capacity. I'm so grateful to serve as a justice alongside such a talented bench in Delaware. I'm so grateful to those in the bench in the bar who took the time to be here tonight, and for your steadfast perseverance through the pandemic, which has been remarkable. One thing must be evident from this lecture, and that is you did not miss a beat. I am deeply grateful to the law school and the people at the ILE who have put together such wonderful programs, including the wonderful program last evening on the Delaware Corporate Law Oral History Project. I also want to acknowledge, and I would be remiss if I didn't do this, the valuable contributions of my former colleague, Justice Randy Holland, a graduate of Penn Law School. When I served with Justice Holland, 3 of the 5 members of our court were graduates of this law school: Chief Justice Strine, Justice Holland, and myself. And finally, I thank my family, and I thank my husband, Les, for his service to country and community and for his loyal support of my service to the great state of Delaware. Thank you very much.
I was going to invite questions, but I feel like you've given us so much to chew on. And we have a delightful reception downstairs where, number 1, we can actually chew. And number 2, where the students may feel less intimidated and it's their opportunity to mob you and ask you some questions. So I think what I will do is invite you all downstairs, but with one final caveat before we go: our second CLE word is appraisal. See you downstairs. Great hall.